Hello, students. Your topic for today is amalgamation and dissolution of trade unions. So, amalgamation of trade union means merger of two or more trade unions into one trade union. Section 24 to Section 26 of the Trade Unions Act 1926 provides for the amalgamation of trade unions. Amalgamation can be as follows. First, amalgamation with dissolution of trade unions. Amalgamation, second is amalgamation without dissolution of trade unions. Third is amalgamation with the division of funds of trade unions. Fourth is amalgamation without division of funds of trade union. So, according to Section 24 of the Trade Unions Act 1926, two or more registered trade unions may amalgamate together as one trade union with or without dissolution or division of the funds of such trade unions or either or any of the trade unions. For amalgamation to be valid, the following conditions must be satisfied. First, at least half of the members of the concerned trade unions must participate and vote for amalgamation, and at least 60% of the votes recovered are in favor of the amalgamation. Now, Section 25 of the Act lays down the procedure for amalgamation for the trade union. A notice in writing as to the change of the name of the trade union after amalgamation must be served by the secretary and 7 members of the trade union to the registrar of the trade unions. If the head office or any other office of the amalgamating trade union are located in other states, notice is to be served to the registrar of trade unions in such other states or state. The registrar of trade unions, on being satisfied with the fulfillment of conditions, registers the trade union by posting an entry in the registrar and issues a certificate to the effect. The amalgamation comes into the force with effect from the date of registration. So, Section 26 of the Trade Union Act 1926 gives provision for the change of the name of the registered trade union. Change of the name does not affect the right and liabilities of the trade union or does not render any defect to the legal proceedings by or against the trade union. Similarly, amalgamation of registered trade union shall not prejudice any right of the trade union or any right of a creditor of the trade union. Dissolution of trade union. So, Section 27 of the Trade Union Act 1926 deals with the dissolution of a registered trade union. For a registered trade union, the rules of such a registered trade union under Section 6G of the Act must make provisions for the dissolution of that trade union. A registered trade union may be dissolved at any time. Second, notice of such dissolution signed by the secretary and any other 7 members of the trade union must be submitted to the registrar of trade unions within 14 days of such dissolution. The registrar, on being satisfied that the dissolution was effected in accordance with the rules of the trade union, will register the fact of dissolution in the register. The dissolution will come to effect from the date of such registration of dissolution by the registrar of trade union in the register. In case of the rules of the registered trade union do not have any provisions for the distribution of funds of the trade union on dissolution, the registrar of the trade union may divide the funds among its members in such manner as he thinks fit. In case the rules of the registered trade union have provision for division of funds, the division of fund will be done in accordance to the provisions in the rules. In case of unregistered trade union and the rules do not have provisions for dissolution, then such trade union may be dissolved with the consent of all the members of the trade union or by an order of a competent court.